Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we've got a bunch of topics to cover, and I'm excited to do that. I'm excited to do that with you. I'm excited to do all sorts of things with you. You catch my drift? I'm just kidding. Man, I need to get this overlay fixed. It's still got the wrong Twitter handle on it. Oh my god, what a disaster that is. Did I boomer the intro? Well, if I did, I'm sorry. You can't win any of them. It's not that you can't win all of them, it's that you can't win any of them. What is... I got off center somehow. I think that's better. You coomered the intro. That's what we're gonna do. Yeah. So yes, this is Law-Splaining the Interwebs. Now later with gayer access to the internet, and I do apologize for my lateness. However, things need to be done in life, and you know, that's how it goes. Speaking of cooming, Milo's. Cracking open a cold Milo's with the boys. So, on the list of topics tonight is a lot of stuff. We've got MxR versus Jukin Media. Jukin Media. They apparently have come to some sort of settlement. They've resolved their issues with a non-disclosure agreement. We'll talk about that a little bit. We'll talk about Legal Eagle's take on it, which I, in fairness, have not finished watching because I don't have enough knives to shove into my eyeballs while going through his very exciting video. So we're going to talk a little bit about that, about his take on it. We're going to talk a little bit about what's been said on the internet, and then I thought we would do this. Jukin Media has done this dance, and I don't know if you guys have seen this, but here is actually a summary judgment decision between Equals 3 LLC and Jukin Media from 2015, and I thought maybe we'd go through that. It's not super long, and it's a great breakdown of relevant fair use analysis in a strikingly similar case involving one of the same parties. So I thought we would go through this in just a little bit as part of that Jukin Media thing. And that's something that I haven't seen a lot of other people talk about, although we know that MxR is probably going to lose everything because they said they were friends with Jeremy Hambley. Or not friends with, fans of Jeremy Hambley, the quartering. And so from now on, they will be P&G'd or whatever. Legal Eagle called me one of the 1,000 teenage lawyers on YouTube. That's good. That's great. The H3 lawsuit was, I don't know if it had anything, I'm not familiar with that specifically. I know that this one is Equals 3 versus Jukin Media, and since it's got Jukin Media in it and it's on fair use over reaction videos, I think it's pretty important to take a look at it. But we'll do that. That'll be fun. We've got the University of Connecticut students who were running around gallivanting, frolicking through a parking lot, and happily yelling the hard R T word through just louder and louder. We've got some updates on those fine, upstanding students who are, one of them has pled guilty, which is great. Take that guilty plea on something that's not illegal. And they are both suing the University of Connecticut, so that's great. And we've got, there's something else going on. that I'll have to see if I can find it on the fly because I don't remember where I saw it. But there's a 1990 order, a court order, stipulated to by the University of Connecticut saying that they won't do exactly what they're doing based on another shockingly similar case. Except I think in this one it said something like homos get the bullet or something like that, which of course I do not endorse. That's a quote from the case, YouTube gods be merciful. But yeah, so we'll talk about that. We've got Chris Hook. Chris Hook has responded through counsel to the sanctions request of $41,000-ish that has been proposed against him in the Allstate case. So we can read through his response, which is just a couple pages, and he even has an explanation as to his very naughty behavior. So we'll talk about that. We've got Vic Mignogna releasing a live stream just yesterday or the day before, with some, he's starting to talk a little bit more about the situation. I don't know if you guys know, but Vic is doing something called the Positive Voice Project, I think, or maybe it's the Rangers. I'm not positive about this. Their messaging has not been saturated enough to reach me. So I don't know much about it. I'm kind of learning about it. You guys probably know more about it than I do. So, but basically it's about being positive and bringing a positive sort of energy to the anime community and voice acting. So something Amanda Winn Lee is really good at. But we'll probably take a peek at that live stream video and talk about that a little bit. We are coming up on 1 year. I think tomorrow is like the 1 year kickoff of everything that started with Vic. And so yeah, we'll kind of see what's going on with that. And Amanda Winn Lee is just having a hard time today, which is sad. Really, I feel for her. And we'll probably start there. We'll probably start with Amanda Winn Lee. But anyway, we got kind of a loaded schedule. It's all a bunch of short things. And I am god-awful at keeping on task. But what I'm going to try to do, I'm going to try and keep things relatively segmented off. Does that make sense? So maybe we'll start with the Amanda Winn Lee thing, move into Vic, and then we'll go from there. And then that way I can maybe keep some sort of order on the show on these separate topics. Oh man, there's other stuff too. I mean, the House has finally signed the articles of impeachment to be sent to the Senate. That's big news because now the Senate can officially tell them to fist themselves. So that's going to be interesting to see. Nancy Pelosi was handing out pens, which somebody said was weird. That's not weird. It's not weird at all, actually. Pens that sign big legislation, pens that sign, whatchamacallit, executive orders, pens that sign military orders. Those are often handed out to AIDS or AIDS victims. AIDS with an E. Sorry. They're often handed out to AIDS or people who are instrumental in passing or promoting the legislation, stuff like that. That's a kind of a common thing. We don't have too many articles of impeachment being passed, so maybe that's uncommon by nature of the Uncommon Act, but that's not a huge big deal. In fact, some of my law professors had pens that a president or whoever had used to sign a specific document. So anyway, there's that. Hey, by the way, shout out to my boy Spectre, who I saw in the chat earlier. Spectre, could you do me a favor? Can you find that Vic video, the unlocked video or whatever, his little chat? I don't know if I have a link of it handy, and just DM it to me. I'd appreciate that very much if you have a second to do that. Let's read through these first chats, and then we'll be on our way with this Amanda Winn Lee thing, and then we'll start rolling through the topics. Hey, thanks, buddy. I appreciate that. TV Goes Live says Joker got 11 Oscar nominations, which is 12 more than Lemoyne's documentary on con sluts. Also, because I'm contractually obligated to bring her up, Mars Girl's arms are longer than the legs on Joker's theatrical run. Oh man, that's some long arms. Long arms. Okay, let me address something else here. I got a message from someone suggesting that they believed, due to a recent post from Mars Girl, that Funimation had hired Mars Girl, and the post is about the timing on some subtitles. Now, without being able to speak authoritatively on it, I would suggest humbly that Mars Girl, I don't believe, has been hired by Funimation at this point. I could be completely wrong on that, but I believe that Mars Girl works for a company that anime companies and other places contract with to do the subtitles, and that she has been doing the timings on subtitles for anime for quite some time, and that it's just that her work ends up at various studios. So I don't want people jumping to random conclusions on that based on half complete information. There would be some potential implications, right? If Funimation were to actually hire Mars Girl to do something, that would send some pretty clear messages. It would be a newsworthy story, in my opinion, not just from a YouTube standpoint, but from the other more traditional publications that have covered this, to have a potential co-conspirator be hired by one of the companies, that would be, or by one of the defendants, that would be something that would be worth discussing, and no one is talking about that. So I think it was a misunderstanding. I just want to point that out in case anyone else has heard that rumor or is thinking along those lines. I do believe that's a long-standing thing. And despite my friends on Twitter always trying to help me out, I do like to keep the misinformation down as low as possible. And I think that one might have just been someone getting a couple key facts wrong. Next, Green Bullet Prod says, watched Your Name tonight, and I'm seeing Weathering with You tomorrow. I'm a full-out weeb, and this makes me feel better. Maybe I can add another movie to my favorites tomorrow. How many chats to make you watch this? How many chats to make me watch what? Your Name and Weathering with You? What are these things? Are these like slice of life anime or something? Thank you, Spectre. I appreciate it. Thank you, Stacy. I also appreciate it. Formula 91 has joined as a member. By the way, I guess I should mention that too. If you notice, there is a join button next to the subscribe button on the channel. I'm obliged to, whatever. I'm supposed to mention it because of business and stuff. But if you're interested in joining up, subscribing to the channel, you get like your name in green, your little badge next to it, and then there's some custom emotes or something, and then there's a couple other perks. One of them would be access to the cooking streams, and there may be more stuff that gets thrown in there as I figure out the system a little more. There, I said it. It's pitched. Done. Moving on. Intimidator 0108 says, hey Nick, how's it going? Got something a little more serious to ask you. Ooh, I'm always open to that. A younger soldier in my National Guard unit recently DM'd me telling me he has Crohn's disease. Was wondering if I could share the GoFundMe in the chat. It's hard to share a GoFundMe in the chat because I had to disable links due to the Chinese porn spam bots. But I don't mind you sharing the information about the GoFundMe. That's up to you. But I can't send a link. you could certainly petition a mod and ask them to share the link. I don't mind. But I also don't endorse GoFundMes that I don't really know anything about. So I'll mention it since you mentioned it, of course, but I'm not gonna say, go do it, because I can't endorse that. Robert H says, Nick, I live in Virginia. The governor just declared a state of emergency. Yes, this is another big story, because people will be protesting anti-Second Amendment legislation this upcoming Monday at the Capitol. Please look into, talk about these laws and impending boogaloo. It's crazy. It's crazy. This is a massive topic. It's a flagrant violation of the Second Amendment. The Second Amendment is a right to keep and bear arms. Keep and bear. Not just keep. Not just keep. That's an important distinction in the Heller decision. Is it's not just keeping the arms that matters. It's bearing the arms that matters. Similar to, of course, we've got Seinfeld, right? It's not about keeping the taking the reservation. I could take reservations all day. It's about keeping the reservation, right? That was the joke. It's keeping and bearing arms. You don't just get to have them locked away in a case disassembled. Oh, well, that's keeping arms, sure. Bearing them. You have the right to bear, which means to have on your person, to maybe even brandish or draw if necessary. So keeping and bearing arms is something that is protected activity. And a governor order saying that you do not get to bear arms because I'm afraid that someone might shoot someone is, governors are always afraid that someone might shoot someone. If we could just not have a Second Amendment because, a governor thought that maybe something would happen, that's going to be very interesting to see. The problem is somebody has to get either shot or arrested for this to become a case. So we'll see what brave soul out there decides to go out with a gun at the protest and get shot or arrested. I would advise it not to be an American of a certain descent, because I would not want the police to automatically shoot them. It's a joke. Don't be a dog either. A dog with a gun is a policeman's worst nightmare. So there's that. But it's gonna be a terrifying time for someone. So Christopher Sanford. But yes, Robert H. I'd love to talk about it more. Man, I want to get somebody on here. I can give you my thoughts. You guys know how I'm gonna think about this. It's a crazy infringement. But I could get. Oh, actually, I think I'm gonna have a lawyer on the show tomorrow. We'll ask him. Yeah, we've got another lawyer who you guys may not have met yet. I've never had him on the show before. He'll be on tomorrow's show. We'll ask him about it and put him in the hot seat. Should be great. Christopher Sanford says, hey, Nick, I'd like to send you a bottle of my favorite tequila if you're interested. It's smooth and smoky and goes down like scotch. And Epstein didn't play Minecraft. No, he did not. Chris, I would love to help you facilitate this transaction. Please send me an email to rekietalaw@rekieta.org, and I will send you an address that you can send it to, because the UPS and FedEx will not deliver to a P.O. box. But yeah, so that'll work. Okay. It's not legal. Why would I have legal on the show? And no, it will not be Kendra Paris, although I am looking to get a Second Amendment panel put together very, very soon. Very, very soon. And Kendra is on the top of my list of guests to ask. So hopefully she'll be up for it. Okay. Here we go. Let's take a look. That's the super chats for now. To all of you new members who have joined up, thank you so much. Well, I'll read them real quick and keep on top. There's 8. Cesario JPN, thank you for joining up. Sonic Jr., thank you. Bad Dragonite, Just a normal bottle of mustard. Yazoo Pacific Sung Jinwoo, Ike 13D, Lance, Parker Tip, and Benj. Thank you all for joining up. I really appreciate it. It's fantastic. It's a great way to help me support the channel and make more stuff. Make more stuff, and more stuff is coming. So let's do this. Here we go. Here we go. This is of course me tweeting about moi, but you know, with my own flavor on it. But this is from Amanda Winn Lee. Amanda Winn Lee. So this this is posted just today at 8:33 a.m. Let's see what she has to say. I'm so tired today. I'm tired of all the ugly in this world. Not in this world, just in world. I'm tired of people finding reasons to stand apart rather than come together. I mean, come on now. And then we've got, tired of pettiness and outrage just for the sake of being outraged. I'm so fucking tired. So, there you go. This is Amanda Winn Lee today. Maybe she's regretting her decisions to do the roast or whatever. I don't know. It must be tough on her. I feel bad. I feel really upset that Amanda Winn Lee is having a bad day after doing something completely classless, with no finger on the pulse, so to speak. That people might have said, hey, that wasn't cool, right? Like, God, it hurts my heart, soul. I just don't know what to do. The tears that I've cried for her all day have now dried, and I'm numb. I'm numb from the tears. But no, this is the shockingly funny aspect of all of this, right? This is no different than what Jamie Markey did, right? She goes on NPR and talks about the harassment she suffered. Vic didn't do anything. These people did the thing, right? I was okay with it 10 years ago. I wouldn't be okay with it today. Well, Lottie freaking da. Vic didn't do anything. You've manufactured something about an event 10 years ago and decided now that that event matters to you when it didn't for 10 years. You guys did this. You guys are the ugly in the world, and you're the ugly in the world. You're both uglies. You're finding reasons to stand apart rather than come together. Your reason for standing apart is that you hate one guy and other people don't hate him. So you wanted to stand apart from them so hard that you're trying to get him removed from life. Do you get it yet? Like, the peaceful people are actually the ones over here being peaceful, like just carrying on with their day. You guys did this. Now you're mad that it didn't work the way you did it, but you pulled out the cleaver and chopped off the sections. That was you. That was you. That was Markey. That was Monica. That was Montello. Although she didn't use a cleaver, she used that excavator that she has slung under her teeth. That's who did this. None of this happens without you guys as the prime mover, because you didn't move on it for 10 years. So nobody believes you. They also know Vic, so they don't believe you. But nobody believes you people. And you don't know what to do about that. Why aren't they just listening to our story? Because it's a bad story. Come up with a better one, I guess. Yeah, remember that moment on stage where all the estrogen was flowing through you, where all of your fellow VAs were bleeding in unison or whatever it was. Like you had all your feminism power in one giant place, and you were flipping off the audience and saying you don't give an F. That was like 3 days ago. What is this? You can't, like, I tell you, if you can't take the heat, get out of the kitchen, but that might be sexist. Anyway, T. Greg Doucette. Oh, thank you for joining up, T. Greg. I've long awaited your approval. Infernal Iris, welcome. Thank you for joining. Zero the Slayer says, can I get a shout out for my fellow Canadians? We are colder than Monica's frigid heart. It's minus 40 degrees Celsius where I am, but some parts are minus 51. Our west coast is also being warned of hurricane force wind. Well, rip Canada. It was nice knowing you. You were a nice hat keeping us warm here in Minnesota, but you will be missed. You'll be missed. And Gelt Walker, thank you for joining up as well. All right, let's move on to this Vic video. Get the headphones. How do I? All right, well, we've got, here's the video. It's on a popular archiving site, so you guys can figure that out. Let me make sure you guys can hear this. Here's the video from Vic Mignogna that he uploaded just a couple days ago, and we'll you know, I'm gonna pause it and add commentary because I don't want him to copyright strike me.
You guys, don't let people pick on you.
Unless they're picking on your gay pants.
And encouraging people to be kind and be positive. And I know that's hard sometimes. A lot of you guys have written me and you've said, you know, it's just really, really hard in the face of such hatred, such venom.
It is tough, right? Like, we're human, and having people basically say you're worse than Satan because you just don't believe them, that gets a little frustrating. And then you're like, well, why should I believe you? Just tell me why to believe you. And then they're like, incel, you incel woman hater, rape apologist. Well, I'm not apologizing for anybody's rape. That's what's happening here, right? Ugh.
These people are sick.
What do you mean, these people?
They are literally emotionally troubled, sick people. To spend their time hurting people that have never hurt them and going after people like they went after the guy that ran this little shop.
So apparently the shop, I'm guessing this little shop, he means the shop he went to on Saturday to do the signing. I'm sure the guy got tons of grief, right? And this is the tactic. And it's really just one angry Harry Ballsack, LJ Montello, who's really going after these people, right? Like, it's just one nasty scrotum out there, just attack, relentlessly attacking, because this is what they do. It's the only thing they do. It's the only thing that can give them any sense of accomplishment, is if they can ruin other people's time through a series of white girl emails. Like, imagine, this is white girl privilege, right? It's even referenced in the movie White Chicks, comedically. But it's a satire because it's got a lot of truth in it, right? I'm gonna write a letter. That's literally what these dumb white chicks are doing. They're writing letters to the management, whomever that may be. Nothing but letters, because they are useless, loveless, soul-sucking harpies. And that's all they have, is they can write endless emails, because they know no one wants to read them anyway. So they have years and years of no one caring what they write, but they know if they write enough, somebody will pick it up. Somebody will pay attention. So they do it over and over and over and over again. They can't stop. They can't. They got a disability.
A couple of these morons went after the guy that runs the shop. They don't know him. He's never done anything to him. He just has this shop and he's trying to feed his family. I'll tell you, I hope at some point these people get just a taste of what they have been dishing out for so long.
This statement is fantastic. Vic has, well, just on Twitter alone, Lemoyne lamenting, "Don't you have 113,000 followers on the Twitter? Don't you have that, Vic? Didn't you?" How many does he have these days? 122,100 followers. "Don't you have 113,000 followers?"
No, I have more. I have more than that. Listen, I have more. You probably didn't get the update. Not your fault. Good try, slugger.
Right? Vic could have, at any time here, he hasn't, could have said, make these skanks miserable, and named them out. He could have named out LJ Montello. He could have named out Renfamous. He could have said, make these defendants, because you wouldn't want to call the defendants skanks, Monica and Jamie Markey. He could have said, make them miserable. He could have people blasting Amanda Winn Lee. He's never actually asked anyone to do that. And imagine if he had. Less than 100 people, by my estimations, less than 100 people have basically put his career in the toilet. Imagine what 100,000 people could do to these if he fired back. Imagine what 1,000 people, he needs 1%. 1% would be 10 times the volume that these sad people put on him. He hasn't asked anyone to do that. You're very lucky, I think. And even still, he's like, I hope one day they get a taste of the medicine that they're dishing out. He still isn't asking anybody to do that. He knows that's what these people do every day. Guys, look at their timelines. Every day they spend in hate. Every single day. They're not laughing, right? Like, I get heated. I get angry at stuff from time to time. I do a lot of laughing. I laugh. The overwhelming majority of my day is spent laughing. It's a goal of mine in life, is just to keep laughing as much as possible. Because I do have a tendency to get angry and to hold on to that. So I laugh a lot. I make fun of people. I make fun of situations. I try to make some other people smile with me from time. That's how I do it. They're missing mirth. They're missing it. They don't have it. I've talked about this before. They don't have joy. They don't have mirth. They don't know how to do that. They don't know how to engage something with positivity or laughter. They must engage it with nastiness. It's their default setting. They do this every day, and they could be undone quickly if someone like Vic had asked for it. Thank goodness he's not a bad guy. Like, because if he was at all shady, the amount of harassment and abuse, like they complain about the random harassment and abuse that they get. If there had been a call for it, oh my God. I mean, ooh.
So you guys don't let yourselves be bullied. Don't let yourselves be ridiculed. Don't let yourselves be put down. And you know what? Stand up for each other. Yeah, you're right. They are bullies. And you know what's really funny and sad is that they were probably bullied themselves somewhere in the past. And
Vic, they're being bullied right now because they're awful. And I'm not even talking about by me. I mean by life. They're awful people. These are people who had potential. They're terrible. They're unlikable. If they were likable, they'd be good at any of this. Never mind. We'll keep going.
Somewhere along the line, they've forgotten what that felt like because now they're bullying others.
They didn't forget.
I don't want to see anybody. I mean, they come after me. I get it. But I don't want to see any of you have to put up with that stuff. So don't let anybody bully you. And don't let anybody hurt you. I love you guys. And I'm so proud of you and your kindness and your support. Oh my gosh, I went long.
Yeah, that was a really long live stream there, Vic. All the way at 2 minutes and 10 seconds.
Oh my gosh. Gotta wrap this up. I gotta reel this in.
I love you guys so much. I know. Oh my goodness! Now my phone says low battery mode. Uh-oh. So I'm out of time.
That's it. That's how he ended it.
So I'm out of time.
Done. Terrible. Absolutely abysmal live streaming skill there, Vic. I love it. Good job. Good job, pal. But again, here's a guy who has been enduring people trying to end his career and life for a straight year. The straightest year of his life. They're trying to end it. And here he is, still saying, just don't be bullied. Don't be bullied. Don't get bullied. Don't let people hurt you. Not fight back. Not knives out. Not anything like that. It's literally just don't let people bully you and don't let people hurt you. That's a year of wearing down on this guy and him toughening up. Oh, they picked him for a reason. Why do you think they picked him? They knew, right? I'm telling you, if someone would have done this to me, if it were me, if I were Vic, and someone had done that to me, there would be proverbial heads. There would be blood in the streets or whatever. Not literal blood, but there would be retaliation. There would be, which is why I'm not where Vic is, right? I mean, that and a whole lot of other reasons. Like I don't do what he does. Can't play music. I don't live in Texas. I would never work for the slave wages that they work for voice acting. None of that stuff too. But no, I'm vindictive. I'm a lawyer, right? Like I want my, I don't want a pound of flesh. I want all of it. So there's the difference there, and they're they're not lucky. I shouldn't say that they're lucky that they picked Vic. They did it on purpose because they know him. Again, that's what makes this so horrifying. They know this about him, and they picked him anyway. They picked the guy who would probably forgive them. They picked the guy who they didn't think would fight back. They picked the guy who for a year, the only statement that they had up until Sunday was, please spread positivity to counter the negativity. And they have made that has been their clarion call, the rallying cry of Vic ordering the harassment of the defendants is, please just be positive and counter the negative falsehoods that you see. That. And now he's progressed all the way up to, they're gonna come after me. Don't let yourself be bullied or hurt. Oh my God. A year, a freaking year. The guy has been called a rapist, a pedophile, a sex pest, sexual harasser, sexual abuser, sexual deviant, a molester. He's been called a sexual predator for a year. And the harshest thing he has said is, don't let yourself be bullied. The man is a punching bag. Oh.
Well, maybe if they come in the gym, they'll hit me instead of you.
Seriously, these are the worst people on earth. Oh my God. Sefi Hakubi says, good evening, Nick. Figure I'd share that I started my music label a few weeks ago, but very considering running a full studio, working with fellow artists and creators that have been disenfranchised. I need to do my part. That's amazing, man. Best of luck to you, or ma'am. I don't know what that that avatar is. Oh. But yeah, go for it. Do it. Frostbeard 2 says Vic sounds like the new guy from the New Guy meme. Andrew Armstrong, Josh Calhoun, and Tetsuo Wrath, thank you for joining up as members of the channel. I appreciate it very much. Hope that what I do with that convinces you to hang around. Do more. Hopefully you like what you see. Okay. I think that about wraps up the Vic stuff. I'm working on something. The year anniversary is technically tomorrow. I've got a lawyer coming on tomorrow. We will not be talking much, if any, about the Vic case. Unless he wants to. We're not going to be talking about that. I'm saving Friday's show for sort of the year anniversary. And we'll see what I can come up with for that. I don't know what it's going to be. I don't want to set expectations high or low or whatever. But we will probably be talking about the Vic case on that day. There's a lot to talk about. Still, there's always a lot to talk about with it. I just try and not say the same things over and over if possible. That being said, Lemois says, the shippers got mad at Vic because he wouldn't endorse the romantic pairing of characters in fan art. John Boyega and Dom Hall Gleason are getting this hate now from Raylo shippers. Yeah. They should ship themselves into the frickin' sea for all I care. Please sign my weird art. Yeah. I don't do that. Polar Bear Diego and Seven Dwarfs, thanks for joining up. I appreciate that. Are they going after the unlocked app? Good. Gotta ruin everything. You do a Vic cosplay for Friday's show. I don't know if I have enough rhinestones, chains, and zippers to sew into a pair of pants by Friday to do that. So plus I don't frost my hair. Okay, what's next? Should we do MxR? Let's do MxR. Yes. We've got
Alright guys, we have an update on the Jukin Media situation.
Oh, no. Don't play it. What is this? This is communism. Just playing a video. Like I want it played. I don't. Not yet. I want to talk about it first. Got it. This is the MxR video. Versus Jukin Media. Now, let me be clear. MxR played this pretty well. Pretty well. Sung Jin Woo, it's the racketeers, buddy. We're racketeers here. The grift is strong with the racketeers. So, they played this pretty well because what they did, and they'll talk about how well this went in the video, they leveraged a community, they got a massive amount of support, and they flexed hard on Jukin Media. They did. And Jukin felt the stress. I mean, if you go to their channel page, all of their videos have been ratioed into oblivion. If you go to their social media, every single post on Twitter, they're getting ratioed into oblivion, being called scammers and awful and blah, blah, blah. They reached out to some person with a dog video and they're like, yeah, not a chance. You guys are scumbags, all of that stuff. They have felt the heat on. They did. And these guys did it without court. I tend to say that court should be your last resort. Even saying the word lawyer should be far down on the poll, because once you say lawyer, the other side clams up and shuts up, and suddenly they can't work with you. You got to work through their counsel, and it's just a mess. Just a mess. And I turn people away quite a bit who want to get a lawyer involved, and I'm like, have you exhausted all of these other avenues? Because this might get you the results faster, cheaper, and with a lot less stress. I want to be very clear that I think Jukin has probably, or not Jukin, I think that MxR has probably played this the most advantageous way to them. And but let's take a look at the video and see what they've got. And if they copy strike me out. Here, oh, I'm not talking loud enough. I turned my noise gate up the other day. Hold on. Let me fix that real quick. Okay, that should be better. I shouldn't cut out now. Okay, Leo Zaro 45 HD says, hey Nick, couldn't sleep tonight, so I'm spending my night with some Rekieta Law and Dark Souls 3. Put this donation towards the drinks fund, and I'd just like to thank you for all you've done for Vic and his fans. Hey, it's my pleasure, and I hope that I hope that Vic's fans hang around for the other stuff. Someone reminded me today, I think it was Corey Goodman. Corey Goodman's a YouTube name. Commented on an old video I did. It was an old live stream. And it said, just doing my semi-monthly watch of this video. And then I clicked on that comment, and there was another comment from like a month ago, and someone was like, going through your backlog, you have some really great content. And yeah, if you have just joined for the Vic stuff, or even if you joined Comicsgate stuff, I've done tons of subjects. And like that video, it was on the erosion of the Fourth Amendment. We went through this pretty interesting case where people were consenting to searches and it ended up burning them. And it's because the police lied, just over and over and over, lied and misrepresented what was going on to the people. And then they ended up getting charged with something that the police weren't even looking for, but they got them anyway. And it was the erosion of the Fourth Amendment was partly from the police and also partly from the party, because they consented to all this stuff. And it really was like it was interesting content. So there is a backlog of stuff I know a lot of people have not seen. So go check out that stuff. You might find something you like in the old live streams or I used to do, before I did live streams, I did videos that were shorter, like only an hour long or whatever. So anyway, let's do this. Sorry. The Greer streams. Yazoo, the big announcement, y'all. Thank you, Yazoo Pacific, a member of the channel, which is why I saw his chat, because his name is green. I have, thanks to a diligent person who is asked to remain anonymous, I have the documents from Russell Greer's criminal charges from when he was in high school. And I have reached out to Sriracha, and Sriracha and I will be doing a show on those documents plus other Russell Greer content sometime in the future. It's been too long. It's been too long since Sriracha has been on the show. So we will, as soon as I can get that set up and we have a mutual time to do the show, when she's available during my time slot, we'll be doing a Russell Greer stream. It'll be soon. As soon as we can set it up. So anyway. Okay. All right, let's do this MxR thing. This is how I prepare for my videos too.
Alright guys, we have an update on the Jukin Media situation. We made a video a few days ago. You might have seen it.
Might have.
It got over 1.5 million views.
I hate edited videos. Let me just put that critique commentary. That's my react video. I hate edited videos. The little cuts. God, it just drives me nuts.
So it completely exploded. I think a lot of media outlets even covered it. I think we made like BBC or something.
Which blew our minds.
It was
like
BBC blew your minds, huh? All right.
very frightening.
Whoa.
Yeah, to have a lot of media outlets reach out to me. Never happened before. You guys really helped spread the word, awareness, and pretty much tons of YouTube channels covered it. Mignogna, Upper Echelon,
the quartering.
The flip side of that is you guys are very scary.
So yeah,
very scary. We've learned that Jeannie should never cry, because when she cries,
all hell breaks loose.
Yeah.
Come on now. The thirst is always real.
And I did not know that, which I think I told Henry this, but I have told myself I am not crying in this
feel
video.
like we need to harness the power of her cries into several gemstones and spread them throughout the galaxy.
They are weebs.
They're like the Thanos.
I
They are
guess
the
that's a
Infinity
Marvel
Stone.
reference.
I think Jukin definitely felt the rage. You know, I'm all for the reasonable emails
And what we think that
and
he
complaints
did,
to Jukin.
yes, what we still believe what they did was unfair, but the part where we heard that people were getting doxxed, like
Welcome to the internet. People get doxxed over everything. You couldn't, I mean, do you guys buy the "we're so naive" thing? Like, these guys seem so naive about everything. I can't believe it. Maybe they are. Maybe they are just pure Maybe there's purity in the world. But I just don't believe it.
Personal private information of employees and the executive board of that company were being like released, like that part.
Is Jukin Media here? Jukin Media. Let's see. You mean did the private information of Jonathan Skogmo come out? Jonathan Skogmo? Let's see. What can we find about Jonathan Skogmo? He's the king of viral video in April 2016. Oh my God. Who else is on their board? Josh Entman, Aldo Carrasco. All of these people have their name is on the Jukin Media Entertainment Company website. I mean, we've got to be careful on what we're calling doxing here. Like these are executives of a company that are listed on the company's website. So who knows what I don't know, maybe someone found a picture of their dog or something that is on Facebook. Who cares? But trust me, the doxing worked out in your favor, guys. It did. I think you know it.
We did not like and were scared, so...
They actually welcomed negotiation, which is...
Shock! They welcomed negotiation. They sent you letters demanding $4,000. Or no, it was $6,000 you'd already paid them too. They sent, you paid them $1,500 or whatever. They sent you letters demanding $6,000 or they'd take down your channel. A bunch of lawyers on the internet basically said that's probably a really bad move on their part. I think to his credit, Leonard French at least insinuated that they might have a case. Legal Eagle is the same milquetoast trash opinion you could expect from Legal Eagle, and we'll play the beginning of his stupid video, his 40-minute video on MxR. We'll play the beginning of that in just a minute. I think Hoaglaw was kind of opposed to MxR. There are other opinions out there, and then you of course have a million people just bombing their social media. Of course they welcome negotiations, but they didn't welcome negotiations. They demanded $6,000 or else from you. Let's be real. I know you've reached your resolution, but at the same time, they welcome negotiations. They weren't negotiating before. What an offer. That was a demand letter.
It's a great thing because we're willing to work together. We had a talk. We came to a resolution I'm very happy with. Ginny is very happy with. Jukin is very happy with. I think in the end, it all worked out. I can't say exactly what the terms are.
Every time you identify one of your videos in one of our videos and let us know without doing a copy strike, we agree to pay you X amount of dollars that is preset, or maybe a percentage of the profit or revenue from that video. That's the agreement they came to. It's great. It's a beautiful thing. It's a reasonable thing. It's what they should have done all along. Jukin should have reached out and said, let's do this, if they wanted to do that and avoid the fair use questions. I'd be surprised if the agreement was much more complicated than that. Look, next time we find your content or our content in one of your videos, we're going to reach out. We're going to ask you for, just like 33% of the revenue your video makes. Because first of all, remember what Jukin Media is asking for to use their video. $50, right? $50. One of their videos gets 200,000 views. That video makes $400-500. They take a third of that, and they've done better for their client and themselves than they would have done just licensing it out for $50. And then these guys don't have them take 90% on the copyright claim for use of, you know, the whatchamacallit, the ad revenue steal or whatever that I forget what YouTube even calls it. They do something like that. It's great for MxR, who can carry on with less risk of copy strikes. It's going to make more dollars per video for Jukin Media that they can pass on to their clients. It's a win-win situation here for everybody, which is what settlements should be. Well, settlements are lose-lose, but basically, this is the type of term. Maybe it's 50%. Still better for both. Still better for both.
But I think if you guys knew what it was, I think you'd be very happy too. But essentially, we should be able to make the videos how we want them and really not have to worry, which is pretty.
I told you. They just have a post facto licensing agreement set up. We can make the videos how we want and not have to worry. They're not going to get copy struck. The revenue isn't going to get taken. They're going to monetize their videos and make more money than they were already making with Jukin taking portions of it. Heck, Jukin may even say, go ahead and use the videos. Go ahead and use them and just pay this amount as a flat licensing fee, whatever you need, if you get over X amount of views.
Pretty much all we wanted. And we've never tried to purposefully infringe on anybody's copyright. As you guys know, we basically go through all the Reddits, and whenever we see a GIF or a video,
a GIF, a jar of peanut butter, what's wrong with you?
Or anything, you know, we'll go through the comments. We'll try to find the YouTube video. We try to find the original source of where it came from. Jeannie will actually go into Jukin Media's database and search for half an hour looking for whatever video she can find. Like, we honestly try our best to play YouTube the right way. And again, we have to thank,
well, they spent a whole half hour.
Thank all of you for sticking up for us, for coming to our support when we needed it. You know, we got a ton of emails, people doing research for us, people just literally alerting everybody on this planet through Twitter about the situation.
Twitter and like through letting all these other YouTube channels know and really spreading the awareness.
Yeah, I think it was a huge learning experience, and I don't think I've ever seen our community be so united for a cause before.
Yeah, I think a huge thing we learned is that how much our community really like goes to what links you guys go to. Again, as we said, some are scary, but besides that, it really overwhelmed us with like warmth and joy to know that you guys are supporting us.
Also, huge shout out to the quartering for reaching out to us. Like,
good job, Hambone.
Almost immediately after it happened.
Yep.
And basically guiding me through most of it and making sure that I stuck up for myself.
Yeah, and basically like helping you keep your sanity for the past like couple or so days.
I'm actually a fan of his channel too. I actually really like his videos. He has a lot of good opinions on things. And
no, MxR, no, don't do it. I'm sure if Jeremy were with me right now, I'm sure he would say, no, buddy, don't say that. Don't do it.
Yeah, we're just glad we have this whole thing kind of taken care of. We can move past it all, finally focus on making videos that you guys want to see and not having to stress about this, which is freaking amazing. So thank you guys so much for your support, and we'll see you guys in the next one. Peace.
Bye.
All right, the little cutesy voice, I just hate it. Nothing wrong with her, but I'm not a big fan of that. So there we go. Also want to give a big shout out to Leonard French, who also immediately looked into our case. Big thanks to the quartering. So there you go. Good job, guys. But yeah, so that's what this was, right? It was it's a settlement. They worked it out with Jukin Media, who is feeling the hurt. Creators these days are not powerless. We're not. Especially the more and more people you get. Do you know, like, even let's take Rekieta Law. Let's not even look at MxR. If I could leverage 77,000 people in a business cause. Like, if I could do that, you have a New York Times best-selling book. You have a Billboard charting music album. And not like a little one. You have bigger comic sales than any comic book in the past, I don't know, several years. You have 77,000 people. Now, I can't, obviously that'd be 100% participation of people who've clicked the subscribe button. That is obviously outside of reality, right? I'm not making any statements about that being something that'll happen. What I want to point out is that, like, that is a massive amount of power. Now multiply it by 14, and you have their channel. That is market force being wielded by people that is hard to find in the world. Except now we creators have that. We have the ability. So yeah, the one thing he said in there that I really liked is Hambly helped him realize to stand up for himself. Yes.
Stock where they buy.
Okay. We've got here's the, God, look at this. Look at that. And all that smug right in one place. That fake bookshelf. Anyway, I wonder if that's green screened in. That just looks flat and weird. Let me thank that guy Mitch. Thank you for joining. Jono NZ, thank you for joining up as well. All right, here's oh yeah, this guy always wears the suit and tie in a video. Guys, I love you, but I would be sweating bricks wearing a suit and tie in the vault, screaming at a camera. That'd be awful. We're going to watch just the first couple minutes of this video. This is 40 minutes long. I just want to go through his synopsis of the case and dispel something right away, because he does this little fear mongering. I bet you don't even own a suit. Of course I own a suit. I was in court today. I had to wear it. I don't want to wear a suit. But all right, here we go. Where's my professionalism? Where it belongs. In the gutter next to Christopher Hook's professionalism. All right, here we go.
The plucky YouTubers behind the channel MxR Plays claim that they're being
extorted by Jukin Media.
Extorted by Jukin Media, all for uploading some reaction videos to YouTube. On the other hand, Jukin says that MxR committed copyright infringement by using their videos without permission. Who's right? Well, I have some good news and some bad news.
What was the jump cut for? Who's right?
For MxR. The good news is that they might have a defense to Jukin's claims. The bad news is that they might not have a defense. I have worse news still. They might not just be liable for the $6,000 that Jukin demands, but actually $600,000 or more.
Let's break that down. Where's that number come from? $600,000, the maximum civil penalty in a copyright infringement case, exclusive of costs and fees and exemplary damages, would be up to $150,000 per video or per infringing issue. Yes, that is true. That is true. The likelihood of getting $150,000 for a reaction video that infringes on a video with a license fee of $49 is not strong. Okay? So, yeah, 150,000 is the theoretical maximum. Now, we're not talking about, there's no bad faith here. It's copyright. If it's copyright infringement because it's not fair use, they probably tried to do fair use, right? It's a reaction video. They're not stealing a broadcast. They're not just uploading the video by itself. They're not doing anything else. The court is likely going to weigh that in the damages. Also, Jukin Media. If someone takes Jukin Media's video, think about this. They are out $50. $50 dues did not get paid because someone took a Jukin Media video. 50. All right? That's like saying you go and you borrow someone's $50 gosh, what's $50? You grab someone's $50 bottle of wine at their house. And you accidentally drop it. So you negligently destroy their $50 bottle of wine through your negligence. Because you rubbed your hand in coconut oil for reasons we're not going to discuss and said, let's see what I can do with this bottle. And then you grabbed it and you started shaking it like this and it just fell and you broke it. So your negligence cost someone $50. You go to court, all right? And they say, look, they negligently destroyed my wine bottle. They're liable for the damages. Well, what damages are you asking? $150,000, Your Honor. But you're out $50. So yes, the maximum civil penalty is $150,000. The likelihood of getting $150,000 on each of these claims is low. They're not serial copyright infringers. They don't have a long list of offenses against this company. They've taken, as far as we can tell, 4 videos that Jukin Media has complained about out of a library that is thousands strong. And again, $50 license fee. This, you guys, people ask me often why I don't like Legal Eagle. Well, here you go. Here's a reason. He's technically correct. Is he practically correct? No. What's the expectation? I don't know. Let's be generous and say that, well, the license fee on these is $1,500 because that's within the demand letter. It's not how it works, but let's say it is. Okay, what? We're going to give him $1,500? We're going to give him triple that? We're going to give him even 10 times that? Still at 15 grand. Right? We're not talking about, let's just say let's just get back to it. The likelihood of them getting $600,000 in this is so low that it's crazy. And
more. And the worst news of all, there's no way to figure out which one is right until they go.
Oh, the worst news is that they may spend $1 million in fees to get it there. Yeah, I mean, you can find a copyright lawyer who would fight this case for less than $1 million. Probably. I'd think.
Go to court and spend potentially $1 million on attorney's fees. So who's right in this whole reaction video debacle? Well, let's think like a lawyer.
Oh God, let's not. Let's not think like a lawyer. Have you guys ever talked to lawyers? They're terrible people and they're awful thinkers. All right, I'm not going to play any more of his video because I don't want to get copyright infringed. Here's the deal. Oh, wait, I've got it. I've got the deal. Is it, hold on. Where's the thing? Is it here? Here we go. Let's take a peek at a case that looks like this. Right? And let's see how this would turn out. Now, to be upfront here, Equals 3 made a mistake in how they did this case. And because of that mistake, this case ended up going to a jury trial. They got a less than favorable jury decision, and they ended up, I believe, settling with Jukin Media separately. Prior to the court order coming through. The mistake equals 3 made in this is that they did not file a cross motion for summary judgment. So here's how a summary judgment motion works. Summary judgment motion, they say that on the facts that are relevant to the decisions to be made here, on the facts, we've got, we agree on all of the facts and we just need a legal decision. Okay. Jukin Media filed for summary judgment. Equals 3 did not file a cross motion for summary judgment. So where the judge found fair use factors in favor of equals 3, had equals 3 filed a cross motion for summary judgment, they likely would have won on those issues rather than going to a jury trial. Okay? But equals 3 didn't agree that they agreed on all of the facts of the case in their cross motion for summary judgment. So rather than burden them with a decision that deprives them of their ability to make their argument, the judge lets it go to jury trial. Had they made the cross motion for summary judgment, they could have won on, I think, 3 of their 4 videos or something like that. But long story short, so this is a summary judgment motion. Summary judgment was granted as far as one video. It was denied for the rest of the videos. And had they made the right moves, they probably could have won the majority of the case outright rather than getting the result they got. But this is still a useful summary judgment decision because it has a great exploration of this specific topic, and we're gonna talk to it. Let's see. We've got Guns Down and Hail. Thank you for joining. Zara BP, Hawk Anime, and Jens Vegaby. Vegaby. I don't know how to say that, but welcome to the channel. You guys have joined up. I really appreciate that. Someone asked, I claim that Legal Eagle had no right to speak authoritatively about Captain Marvel scene because he hadn't seen the movie. I don't think that was my claim. I think he was ignoring the fact, the amount of power that she had. I think she's a walking demigod, and his speaking authoritatively was just flatly incorrect. It's just wrong. His use of force assessment is not accurate. Again, to put a comparable use of force assessment on what he said was okay in Captain Marvel. Take the biggest, strongest man you can think of. Like a half Thor, right? Like you've got half Thor Bjornsson, world's strongest man, 7 feet, like 450 pounds of Icelandic terror. Okay? Now, you take a 5 foot, 100-pound woman, and half Thor is reading a book. He's got a little tiny book sitting in his giant mitt. And she pulls the book down and she says, "You should smile more, big guy." And he just punches her into the next room. And then he goes and he rips her clothes off and wears them. And then steals her motorcycle. That's the situation of Carol Danvers. Like, beating the guy, right? Like, that's the exact same story. You have a wild disparity of power. It's obvious to the one who wields the power that there's a wild disparity of power. You've got disproportionate use of force. You've got what may be, in some legal theory, a textbook battery because he touched something that the person was in their possession. But the response to that battery is not to break the wrist while electrocuting him and then steal his clothing and motorcycle. This is what I'm talking about. His opinion is ludicrous on its face. It's not a proper use of force assessment. And it only works because Marvel is pretend and Brie Larson is the powerful one in that situation, despite being a smaller woman versus a man. That's the irony. That's the dramatic irony at play. Like, that's why the scene was filmed. They also probably realized how stupid it was, which is why it was cut. But anyway. So that being said, let's get into this thing here. So this is Equals 3 versus Jukin Media, and we're gonna skim through a lot of this stuff. This copyright action, centering around funny videos, presents issues that are anything but simple. The instant motion requires the court to evaluate whether a humorous use of viral videos is a fair use. This complicated inquiry requires the court to make distinctions along the fuzzy boundaries between commenting on humorous videos in a transformative manner and simply exploiting them for their inherent humor without paying the customary price. On November 21st, 2014, plaintiff and counterclaimant defendant Equals 3 LLC sued defendant and counterclaimant Jukin Media for a declaratory judgment and for relief under Section 512F of the DMCA, which prohibits fraudulent use of DMCA takedown notices. Jukin counterclaimed, asserting that Equals 3 infringes 19 of its copyrights. Presently before the court is Jukin's motion for partial summary judgment regarding fair use. For reasons discussed below, grants in part and denies in part the motion for summary judgment. Factual background. Jukin is a digital media company. Remind you, this is in 2015. That amasses a library of user-generated internet video clips to license on the creator's behalf. Jukin employs a research and acquisitions teams of 11 people to scour the internet for videos likely to go viral, become sensationally popular. Jukin's employees then locate the video's creators and enter licensing agreements with them. Jukin has a library of over 17,000 short-form videos. I don't have easy access to the footnotes, so we'll... Jukin uploads these videos to its YouTube multi-channel network and to Jukin's own content-focused websites. Jukin also uses these videos to create digital productions, which Jukin distributes on its YouTube multi-channel network and websites. Beyond arguing these productions are original, Jukin does not offer evidence regarding the precise nature and content of these digital productions. Jukin also monetizes videos via ad-supported or subscription-based third-party syndicators, which take responsibility for content distribution and use their videos to generate advertising revenue. All those viral videos you like, Jukin creates them. Apparently, they talent scout and put them out there for you. And then they have people who promote them and distribute them. And yes, I'm sad to say that your viral video sensations are manufactured by big companies. Many, if not most, of the time. So... Equals 3 does not dispute the fact that Jukin's partner includes these two shows, but argues that the shows are distinct. Oh, wait, sorry. Jukin's partners includes What the Fact Show and The Young Turks. It's The Young Turks. The Young Turks. It all goes back to chunk yogurt, which Jukin describes as YouTube shows that are similar to Equals 3's shows. Equals 3 does not dispute the fact that Jukin's partners includes these two shows, but argues the shows are distinct from Equals 3 shows. In support of this argument, Equals 3 offers the declaration of its executive producer, Kadiatu Martin. Martin states that The Young Turks is distinguishable from Equals 3 because it is a politically charged news and current events show, and the What the Fact show is distinguishable from Equals 3 because it is in Spanish, it plays viral videos one after another in no particular arrangement, and the host offers few remarks. Equals 3 produces short humor programs, which it broadcasts via YouTube. Its humor programs typically involve a host who gives an introduction, shows parts of video clips, which are usually shown in edited form and inset within a decorative graphical frame, and remarks about the events and people presented in the clip. In each episode, the host weaves an originally crafted humorous story theme throughout the episode using multimedia content, text, graphics, and animation, sound effects, voiceovers, and video clips to enhance and develop the story. Often, portions of the viral video are shown more than once during a single Equals 3 episode. Hosts will frequently offer an originally authored monologue and will provide spoken and performed commentary on the various video clips. This is a great way to describe a reaction channel, isn't it? It sounds like a really sophisticated endeavor. But between him just replaying the guy getting hit in the nuts and going, oh, right in the pills. Oh, right in the satchel. Oh, right in the coin purse. Right? Like, that's okay. I'm not trying to denigrate equals 3. I'm just saying, like, the way they're describing a reaction video is kind of funny. So originally authored monologue and will provide spoken and performed commentary in the various video clips, including facial expressions, sarcastic remarks, derisive commentary, sexual innuendo, and social commentary directly targeting and referencing the people, events, and circumstances depicted in the source videos. It's a reaction video. Each program is roughly 5 minutes long. Man, by the sound of that description, it took longer to read the description than it did to watch the video, and typically features 3 segments, each of which centers around a different video. Equals 3 also offers its executive producer's declaration that stylistically, the E3 episodes feature frequent jump cuts and are edited to appeal to fast-paced tastes. Equals 3 typically obtains source footage for its show by scoring the internet for source videos. Jukin argues that Equals 3 directly targets its videos, but fails to offer any evidence beyond rank speculation proving this fact. Equals 3 provides its creator's declaration that Equals 3 does not target Jukin. There's a fact in dispute, although it's not really relevant to fair use. It is undisputed that Equals 3 uses portions of Jukin's videos without paying a licensing fee. Each of the subject source clips from Jukin is a user-generated video featuring either a slapstick-style mishap, an animal in a humorous situation, or simply a cute video of an animal, such as a dachshund chasing a crab on a beach. Jukin asserts that Equals 3 infringed on its videos as follows. So here you go. Here are all the things you guys can look at that if you want. Trampoline hump dog. All right. It is undisputed that each of the allegedly infringed Jukin videos was published before Equals 3 alleged use of that video. March 12, 2014, Equals 3's then host Ray William Johnson announced that the Equals 3 show would be going on hiatus to find a new host. When Jukin heard that Equals 3 was to resume its broadcast, Jukin contacted Equals 3 to inform them that any use of Jukin's videos would be considered infringing. Jukin's letter indicates that Jukin is willing to negotiate a license agreement and indicates that Equals 3's willingness to link to and credit Jukin's content is not sufficient. It is undisputed that no license agreement resulted. There is no license required for fair use. Let's be very clear on that. Fair use is not... fair use is not a thing that you do to avoid copyright. Fair use is a new creation. It is protected by copyright. If Jukin were to take your fair use property and upload it back to their video, why am I still wearing these? They would be infringing on your copyright. Okay? Fair use is an integral part of copyright. So it's weird because we articulate it as a defense to copyright, which it is, but it's also more than that. It's an original work that just happens to use some other work in it. Okay. Big Red 64, welcome to the show. Thank you for joining. Okay, on July 16th, Equals 3 resumed broadcast and published its episode titled The Resurrection. It is undisputed that The Resurrection used Jukin's video Black Bear Milk Bottle Rescue. Equals 3 responded to Jukin's July 9th letter. On July 25th, Jukin sent a letter to Equals 3's counsel with an attached invoice for Equals 3's use of Jukin's videos. Jukin argues that Equals 3 never responded to the July 25th letter, never paid the invoice, and never attempted to negotiate a license. Equals 3 asserts that since May 1st, Jukin has filed at least 41 copyright infringement claims with YouTube regarding Equals 3's episodes. Once such a claim is filed against an Equals 3 episode, Equals 3 can no longer earn advertising revenue from that episode. Additionally, once Jukin has filed a claim against the episode, Jukin can place advertisements on the episode, redirecting viewers to its own YouTube channel. I don't think that's exactly how that works, but okay. The parties agree that the fair use issue is ripe for adjudication. This issue may be dispositive of the case. As the status conference held on February 9th, the court set a briefing schedule regarding the instant motion for summary judgment. So here's the legal standard. We're going to skip this because this is all about procedural stuff with summary judgment, and this video will get really long. Let's see. Where do we want? Let's get to this fair use analysis. Here we go. Fair use. The fair use doctrine has been called the most troublesome in the whole law of copyright. Copyright Act provides that fair use of a copyrighted work, quote, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use of a work is a fair use, courts should consider the following factors. 1, purpose and character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or value of the copyrighted work. These factors should not be treated in isolation and instead must be explored and weighed in light of the copyright's purpose. Supreme Court has found that transformative uses lie at the heart of fair use doctrine's guarantee of breathing space within the confines of copyright, because such works generally further the goal of copyright to promote science and the arts. Purpose and character of the use. So here the court is now going to weigh through all of the factors, the 4 factors, and then we're going to get the conclusion and the order. It's the first factor is the longest, but bear with me. We'll focus in on the key parts. Key inquiry for the first statutory factor is whether and to what extent the new work is transformative. A new work is transformative when it does not, quote, merely supersede the objects of the original creation, but rather add something new with a further purpose or different character, altering the first with new expression, meaning, or message. The, quote, more transformative the new work, the less will be the significance of the other factors that may weigh against a finding of fair use. If the work is more transformative, it becomes the most important factor, basically. The preamble to Section 107 lists criticism and comment as illustrative bases supporting fair use under this factor. Additionally, the Supreme Court has stated that parody has, quote, an obvious claim to transformative value. Nevertheless, there are no bright line rules. Fair use must be evaluated on a case-by-case basis by reference to the 4 statutory factors. And this is where, credit to Legal Eagle, this is why copyright actions aren't so simple that you can say it's definitely fair use or definitely not, because it is case specific. Both works, there's no, I mean, you would have to have identical situations, identical videos, identical subscriber numbers, identical distribution, identical everything to have an exact same case, and that doesn't exist. So each one does have to be evaluated case by case. That's why attorney's fees can get kind of expensive in copyright. That's why you should really consider, if you get a copyright strike on YouTube, if they're willing to go to court, or if you are, because it could be very expensive either way. All right. Equals 3 asserts that its episodes are transformative because they are parodies of the Jukin videos. Jukin argues that Equals 3 episodes are not parodies because they do not critique Jukin's videos. According to Jukin, Equals 3's episodes are at most satires of society or some other subject in general. A parody is a work that uses, quote, some elements of a prior author's composition to create a new one, at least in part, or that at least in part comments on that author's works. In contrast, satire has been defined as a work, quote, in which prevalent follies or vices are assailed with ridicule or attacked through irony, derision, or wit. Thus, parody needs to mimic an original to make its point, and so has some claim to use the creation of its victims or collective victims' imagination, whereas satire can stand on its own 2 feet and so requires justification for the very act of borrowing. Determining whether equals 3's episodes parody Jukin's videos is a difficult and nuanced task. As pertains to this case, Jukin's videos are typically short, point-and-shoot style depictions of events that actually happened. These events typically, and that goes against them, by the way. These events typically have an unplanned or spontaneous aspect to them, such as an attempted boat stunt failing or a child having an unexpected reaction to the news of his mother's new pregnancy. Jukin asserts that his video's purpose is humor and entertainment. It's difficult to say whether equals 3's episodes, which undisputedly use graphics and narration to tell jokes about the events depicted in the videos, criticize these videos, which were themselves made to serve the purpose of humor and entertainment, or simply point out their inherent humor. Nevertheless, even if equals 3's episodes are not parodies, the episodes comment upon or criticize Jukin's videos. Equals 3's episodes directly respond to and highlight humorous aspects of Jukin's videos. The episodes do so via the host's reaction to the videos, jokes, narration, costumes, and graphics. So the court just lays out that they might not actually qualify as parodies. But the court is simultaneously laying out, or subsequently, I guess, laying out that they don't actually have to be parodies to be transformative. The response, the comment and criticism comes from the reaction itself, including just the host's reaction to it. That is part of the creative thing. And of course it is. Of course it is, because if you have two dummies reacting to the same video, one might be funny and one might not be. You might like one and you might not like the other. Those differences in facial expressions, like Ginny crying or whatever, apparently Ginny crying is like the worst thing on earth, but you get a fat Matt Jarbo crying, and it's a completely different thing, right? Petite Asian girl versus Matt the Boulder, both cry, and you get two disparate effects. When Ginny cries, the earth moves to get Jukin Media to the table. When Matt Jarbo cries, everybody just makes fun of that fat baby, right? Like, that's it. The host's narration does not simply recount what is shown in Jukin's videos. Instead, the host makes comments about Jukin's videos that highlight their ridiculousness by creating fictionalized narratives of how the events transpired, using similes, or by directly mocking the depicted events and people. Equals 3's episodes also repeat portions of Jukin's videos multiple times within the same segment. For example, the Equals 3 episode entitled The Resurrection uses part of Jukin's video Black Bear Milk Jug Rescue. Jukin's video shows, among other things, footage from a distance of the bear in a field. At least 3 attempts by a tractor's crane to grasp the milk jug on the bear's head, crane successfully clasping and removing the jug from the bear's head, and the bear running away. The Resurrection shows, among other things, some shots of the crane next to the bear with the jug on its head, one unsuccessful attempt by the crane to grasp the jug, crane successfully grasping and removing the jug, and part of the footage of the bear running away. The host makes such comments as, playing the crane game at Chuck E. Cheese's wasn't a waste of time, and compares using a crane to remove the jug from a bear's head to fishing with a hand grenade. The Equals 3 episode Drunk Babies uses part of Jukin's video Groom Drops Bride. Drunk Baby shows Jukin's video, the groom running while carrying his presumed bride, tripping and falling on her. Great video. Great video. Drunken Baby shows the footage of the actual trip and fall multiple times with different graphics and commentary interspersed. The host makes such comments as, shit, he literally body slammed his new bride, and describes the incident as an example of why you shouldn't wait to have sex until marriage because you get way too excited. Oh. God, was 2015 that bad, guys? Was 2015 that rough? In plain terms, whether or not Equals 3's episodes criticize Jukin videos, the events depicted in Jukin's videos are the butt of Equals 3's jokes. Thus, the jokes, narration, graphics, editing, and other elements that Equals 3 adds to Jukin's videos add something new to Jukin's videos with a different purpose or character. This is not a case where the addition of minimal narration, an introduction, or text did not change the essential character of the original work. See, this is what we're talking about here. If you just say, hey, I'm going to show you this video by Jukin Media, and then you do that and say, in this video, there's a crane and it's trying to take the jug off of a bear. They got it. The bear runs away, right? Like, if you're just narrating for the blind, That's not transformative. That's not. But if you throw in jokes, if you add criticisms like, why use a crane? I would have used dynamite or something like that. That type of thing starts to change the nature of the work. It changes what's happening. It's not just descriptive of what's happening on the screen. It's critical, commenting. It's adding something. So this is important. And now, I don't know what MxR's reaction videos are like, okay? This is the questions they have to go through in determining how hard they want to fight this, if they were to take this to court. That's what I'm pointing out here. This is not a case where the addition of... read that. This is also not a case where Jukin's videos are used, quote, to get attention or to, quote, avoid the drudgery in working up something fresh. For the aforementioned reasons, court finds equals 3's episodes, except Sheep to Balls, highly transformative. Sheep to Balls is not transformative, y'all, just so we're clear. So again, citing National Center for Jewish Film versus Riverside Films, finding that defendants' use of footage was transformative, where their voiceovers, editing, and overall production added something new to the underlying footage. Equals 3's use of Jukin's videos is admittedly commercial. Nevertheless, the commercial nature of the use is outweighed by the episode's transformativeness. So they're both commercial. Jukin's trying to make money. Equals 3's trying to make money. And that's a factor that they do in the nature of the work. But if it's transformative, it doesn't really matter if it's commercial or not. Finding insignificant the commercial nature of defendant's work where defendant's use was transformative. This is what I was talking about. Transformative or fair use isn't just, like, it's not just a defense of copyright. It is a new thing under the protective umbrella of copyright itself. The one exception to the aforementioned analysis is equals 3's episode entitled Sheep to Balls. Sheep to Balls uses Jukin's video of the first person to buy an iPhone 6 in Perth dropping the phone. According to equals 3, it used this footage for the purpose of making 2 points. 1, don't be first at shit. And 2, Apple Inc.'s method of packaging iPhones at the top of the box is absurd. Equals 3 thus admits that its purpose of using Jukin's video was to make 2 general broad points that were not directly aimed at criticizing or commenting on the video. The use of Jukin's footage to make these 2 points is akin to using news footage without adding anything transformative to what made the footage valuable. In this case, a clear view of the first person to obtain the iPhone 6 in Perth dropping the phone upon opening its package. So the video is inherently about what they wanted the video to be about. So the court here is saying, well, that's not transformative. That's just what it is. That's just what it is. Is it transformative if the comments come after the clip is played? Maybe. That's a good question. It's case by case. It depends on the comments, I suppose. Oh, man. Oh. I felt better. Finally, the court does not find that equals 3's purported bad faith in not obtaining a license mitigates against fair use. If the use is otherwise fair, then no permission need be sought or granted. Jukin Media obviously does not care, right? And they still don't, even after this ruling, they still play the same way, right? We want the licensing agreement. They'll play hardball with you. Apparently, if you just stand up for yourself, they'll back off. If using a song after requesting and being denied a license does not show bad faith, then neither does failing to obtain a license and continuing to use footage after being sent a demand letter. C. Campbell here, finding that being denied permission to use a work does not weigh against fair use. Moreover, there is no evidence that equals 3 did not in good faith believe that it was making fair use of Jukin's videos. See Campbell again. The court is similarly unpersuaded by Jukin's argument that equals 3 unfairly reaps the benefits from the time and money Jukin spends selecting its videos. For the aforementioned reasons, the court finds that equals 3's episodes, except for Sheep to Balls, are highly transformative. Thus, for all episodes except Sheep to Balls, this factor weighs heavily in favor of fair use. Now, remember, the transformative part is one factor of the 4. The nature of the copyrighted work. This is another factor. Is this widely published? Is it for money? All of that stuff. This factor looks at the extent to which the copied work is creative and whether it is unpublished. Courts recognize that creative works fall closer to the core of the copyright's protection. Here, it is undisputed that Jukin's videos were all published before Equals3 used them. However, it is more difficult to determine the extent to which these works are creative. The Ninth Circuit has recognized that a point-and-shoot photograph is not on the same level as the works of famous photographers. Nevertheless, the Ninth Circuit has also found that just because a photograph documents an event does not turn a pictorial representation into a factual recitation. Here, the largely point-and-shoot videos do not exhibit the cinematic masterpiece of many famous film directors. Nonetheless, the court cannot say that they convey mainly factual information, right? So they're giving some credibility to the framing of the shot, the timing of the shot, the lighting that it's shot in. All of that sort of stuff is weighing into this. I mean, it's point and shoot nature, but you know, just because it's not Scorsese doesn't mean it doesn't have value. It's not on a pedestal, some normal thirds angle or thirds framed shot, like C-SPAN, right, where the camera just sits and focuses on the same spot, and then what happens on the screen is what's happening. That's a little bit different. So then, while the entire episode of The Ed Sullivan Show or the individual performances may be near to the core of copyright, the clip at issue conveys mainly factual information who was about to perform. Thus, the court finds that the nature of Jukin's work is creative, so this weighs against fair use. Nevertheless, the copied work's creative nature is not particularly important when the new work is highly transformative. So this factor matters a lot on Sheep to Balls. Doesn't matter much at all when it's highly transformative. Thus, while the factor favors Jukin, it carries only slight weight, something that Jamie Markey is not familiar with. Amount and substantiality of the portion used. The third factor looks to the quantitative amount and qualitative value of the original work used in relation to the defendant's justification for the use. Jukin does not argue that Equals3 uses his videos in their entirety. Instead, Jukin complains that Equals3 takes the most important parts of its videos, their heart. Now, this is actually different. If they use the entire video, that can actually weigh against fair use. Supreme Court has recognized that a parody may need to take a work's heart in order to conjure up the original and achieve its parodic purpose. Equals3 asserts that it uses no more of Jukin's videos than is necessary to achieve its purpose of criticizing and commenting on Jukin's videos. The court agrees. Though Equals3 uses the arguable heart of Jukin's videos, it does not show more than is reasonably necessary to convey enough of the events to allow the host's jokes, comments, and criticisms to make sense to the viewer and resonate. So this is important as well, because if you notice, there's no bright line rule here. You can use an entire video. Like I just used that entire Vic video, right? I don't think Vic's going to copyright strike me. Maybe he would. And if he does, I'm coming for you. Maybe he would, but if he did, I added significant amounts of commentary, talking about different things going on in the community and such, and talking about some theory about what could have been if Vic had done things differently to what he did now, and criticizing him and making a few jokes in there as well, and criticizing the other people that are the subject of his video. Now I use the whole thing because, or I think I cut off the last couple seconds, but we'll just say I didn't. Remember, it shut off on its own. I used the whole thing because I thought that using the whole thing was necessary to convey the messages that I wanted to convey. There were parts of it, there was places for commentary throughout the entire work. So whether or not you used all of it or not isn't dispositive and isn't the only question here. It's whether or not you use the appropriate amount to convey what was necessary. And that's a question that's on a case-by-case basis again. The fourth factor, this is the final factor, looks to the effects of the use upon the potential market for or value of the copyrighted work. This inquiry requires courts to consider both the extent of the harm caused by the alleged infringer and whether unrestricted and widespread conduct of the sort engaged in by the defendant would result in a substantially adverse impact on the potential market for the original. This inquiry must include harm to the market for the original and harm to the market for derivative works. However, the law does not recognize a derivative market for critical works. Market harm caused by effective criticism that suppresses demand is not cognizable. So again, if it's highly transformative because it is critical of the original work, then that doesn't create market harm. This is, of course, what we want, right? If you're watching MxR for them and the thing they're adding to Jukin's video, then that can never harm the distribution of Jukin's video because you're not watching MxR's upload of Jukin's video. You're watching MxR react to the video. You want their take. You want their reactions, their input, their faces. You want that. So you wouldn't have otherwise watched the viral video. You watched the reaction. Does that make sense? Okay. Instead, the only kind of harm cognizable is market substitution, i.e. where the new work diminishes demand for the original work by acting as a substitute for it. Thus, where a work is transformative, market harm may not so readily be inferred, and there is no presumption of market harm. Jukin argues that the market for its original video is harmed because Equals 3 frequently copies his videos during the time when they are allegedly most valuable, shortly after their publication. That's actually probably not true. For Jukin, for most people, the first 48 hours is the big thing. But if they're creating viral videos, I don't think the first couple hours actually support that theory. But anyway, in support of this contention, Jukin offers only the declaration of Christina Smith, its vice president of content operations. Smith gives no foundation upon which she bases this speculative conclusion. She simply makes a conclusory assertion that Jukin's videos are generally most valuable within the initial days and weeks after their publication. Smith also acknowledges that sometimes an older video becomes more popular and valuable only after Jukin promotes it. Smith gives no specific facts regarding the value of the videos at issue in the case before or after Equals 3 used them. Moreover, even assuming arguendo that the videos are more valuable shortly after publication, focusing on harm from Equals 3's failure to pay a license risks circular reasoning. If Equals 3's use is fair, then no license fee is required by it or other similar users. Jukin further argues that Equals 3's episodes usurp demands for their videos. In support of this argument, Jukin offers evidence that licenses its videos to shows which it claims are similar to Equals 3's. However, as stated above, there's no cognizable derivative market for criticism. Thus, Jukin's argument fails to the extent that Jukin claims harm to a licensing market for shows that critique and mock its videos in the manner that Equals 3 does, which just means that they're charging to people who shouldn't pay if the shows are similar. That's what the judge is saying here. Excuse me. Nevertheless, court must still consider the possibility that Equals 3's viewers use the episodes as a substitute for Jukin's videos. Jukin claims that viewers no longer need to watch its videos after watching Equals 3's videos. Equals 3 claims that its episodes actually increase Jukin's video views. Neither side submits admissible evidence strongly supporting its position. Jukin submits no admissible evidence showing that a single viewer actually watched Equals 3's episode rather than Jukin's video, or of any instance which it lost a deal to license its videos. Instead, Jukin relies on Smith's unfounded testimony that Equals 3's viewers no longer need to watch Jukin's videos. Jukin also relies on the conclusory statement of its director in licensing, Andrew Dignan, that Equals 3's use of Jukin's videos decreases their licensing values. However, Dignan's only support for the statement is that, quote, for instance, a potential licensee is less likely to license a video if they think others are copying it for free. Equals 3's use of Jukin's videos contributes to a culture of infringement that gives the impression that to other potential licensees that they do not need a license to use the content. Dignan fails to offer sufficient foundation to support this broad, unsubstantiated statement. Plus, as stated before, if Equals 3 wouldn't need to pay because it's transformative, then neither would anybody else. To support its position, Equals 3 relies on primarily on its employees' inadequately supported testimony on an unauthenticated statements purportedly from Equals 3's viewers to show that its viewers also watch Jukin's videos. Equals 3 also speculates that when one of its viewers wants to rewatch a particular source video or to share it on the internet, the viewer will likely go to the video's original source rather than rewatching Equals 3's episode. Equals 3 should have reached out to viewers to get some sworn statements. Anyone who is comfortable doing it. Equals 3 also submits evidence that there's no way for one of its viewers to share a source video containing Equals 3 episode without having the recipient watch the entire Equals 3 episode. Equals 3 fails to submit admissible evidence defining the relevant market. While the transformative nature of Equals 3's videos makes cognizable market harm less likely, court cannot say that it is completely implausible that at least some viewers would substitute Jukin's videos with Equals 3's videos. This weighs against that 150,000 award pretty heavily. Like that line. That it's not completely implausible that at least somebody might substitute a video somewhere. Both videos are meant to be humorous, and the court can imagine a fine line between the demand for the humorous original and the humorous new work commenting thereon. Nevertheless, there's no actual evidence of any such harm, and as discussed above, Equals 3's episodes do not take excessively from Jukin's videos. Thus, on this record, where any market harm remains hypothetical, the court finds that this factor does not favor either party. Conclusion. Court must now weigh the 4 factors in light of the copyright's purpose. Doing so, the court notes that transformative works generally further copyright's goal of promoting the arts and sciences. Here, Equals 3's episodes, except Sheep to Balls, are highly transformative in use of Jukin's videos. Only what is reasonably necessary to achieve their transformative purpose. First and third factors thus strongly favor fair use. There's no proof of cognizable harm to any actual or potential market, and thus the fourth factor favors neither party. Moreover, though the second factor weighs against fair use, it is of little weight in light of Equals 3's episodes' transformativeness. Moreover, Jukin's videos were published before Equals 3 used them. Thus, on balance, the factors weigh in favor of fair use for all episodes except Sheep to Balls. Therefore, Jukin has failed to carry its burden. However, as discussed above, Sheep to Balls is not transformative, is likely to cause market harm. Thus, it does not make fair use of Jukin's videos. Grants in part and denies in part. So here's how this works. Jukin won on the one video. The Sheep to Balls video, they win. And there would presumably be some sort of damages that would be awarded to them in favor of that. Now, the motion for summary judgment is denied in all other respects. That means on the 18 cases they lost. The 17 or 18 other videos they lost, and that means that what happens is this went to trial. Now at trial, again, as I mentioned before, Equals 3 maybe screwed up in their filing and didn't file a cross motion for summary judgment, and I believe they ended up losing at trial, but settled with Jukin outside of court for it. So we don't know what they ultimately settled on. But there you go. This gives a great guide on how to run a reaction channel. It's right here. Here's exactly what the court is going to consider on reaction videos. Is the original video funny and your reaction video is funny? Okay. Now you have to do some extra work to make it transformative. Are you critiquing the video or are you just narrating the video? If you're just narrating the video, not transformative enough. Critique it. Ask questions. Make fun of it. Pose alternatives. Tell a story. All of these things are in there. This is how we do it. So what MxR would have to do on those 4 videos that Jukin Media was claiming is they would have to make a fair use assessment. Do they want to fight for this? And Jukin would too. And then, do they want to take it through the copyright court? Maybe. Maybe not. It could be very expensive. Does Jukin want to take it through the copyright court? Do they want to go to court and get hammered on this? Remember, Jukin stands to lose a lot, because if they lose the case, they risk setting, further precedent. But anyway, all right. So that's the MxR decision. I thought you guys might find it interesting to see how the court looks at this sort of stuff, right? This is how the court would determine MxR's case in the same way. And I don't know what 4 videos they had Jukin mad about. I don't know, so I can't tell you. I think it was 3 videos and one of them had 2 clips in it. I couldn't tell you what my assessment of the fair use factors are. And there is no definite answer in copyright. You just have to go and have a judge decide. So there you go. All right, what is next on the agenda? Let's quickly talk about this University of Connecticut stuff. Here we go. Oh, come on. That's terrible. We'll read this one from, I guess, the Washington Times. We're not going to read through the whole thing, but here's what's going on with this University of Connecticut stuff. Ah! Sorry, there's a giant video of weird animals. Oh my god. Okay, where are we? We'll do Chris Hook next. This one won't take too long. I just want to give you an update. So here's the this is them chiding the lawyers. That's not, or chiding the school. This isn't what I want, actually. Hold on. Oh, well, here we could, there's two different stories. Here's this one. UConn student gets special probation on racial slur case. Thanks for bowing. Oh, I hate everything. Thanks for bowing to the man on this. It's really helpful for the First Amendment. One of two UConn students charged with yelling racial slurs outside of the university apartment complex was granted a special form of probation Tuesday. It could result in the charge against him being dismissed. Jared Corral of Plainsville will be on probation for 6 months and must complete 20 hours of community service and undergo diversity and bias training. So he can be a good little proper thinking member of society. Thank God. Thank God. Rockville Superior Court Judge James Sicilian approved his application for accelerated rehabilitation, finding that his offense was not of a serious nature and that it was unlikely Corral would offend again. UConn police charged him and another student, Ryan Mukaj, of Granby with ridicule on account of creed, religion, color, denomination, nationality, or race. The charge is a Class D misdemeanor punishable by up to 30 days in jail, a fine of $50, or both. Mukaj's case is still pending in the Superior Court of Rockville. Don't take the deal. Oh, please. Somebody represent these guys for free. Get in there and fight. Prosecutor Thaddeus Beauchain told the judge he was in favor of Corral receiving accelerated rehabilitation. There was outrage, Beauchain said. This was something from the state's perspective that was serious and concerning. Then the state needs to end. If this is serious and concerning to the state of Connecticut, then the state of Connecticut is no longer welcome in the union. Get out. Get the hell out of my country. Get out. They weren't saying it at anyone. There's no threat. There's no violence. It's just two dummies walking through a parking lot shouting. That's it. That's the extent of it. There were protests and concern. Listen, this is a prosecutor. This is a state prosecutor justifying the arrest and charge of crimes. Why? There was outrage. It's serious and concerning to the state. There's protests and concerns from the community and of the UConn community and the community as a whole. There are a few words that carry the hurtful import as the racial slur. This man drops the N-bomb. I'm guessing. What did he? What's the actual quote? Does he just drop the hard R in the quote? They bracketed it out. Why? Beauchain also noted that alcohol played a role as well as Corral's youth. What the fuck are you talking about? His youth played a role? Correct me if I'm wrong, because I think you're more likely to find a 70 or 80-year-old person dropping a hard R than a 20-year-old college student. So that's a weird statement. At the same time, he added, Corral did take responsibility for his actions. I did yell the T word. I did, Your Honor. I did. I'm so sorry. Can you imagine doing the bitch up in court for a word? For a word that you said to nobody. Your Honor, I deeply regret my actions. I've thought long and hard about it. I mean, I would never make the same mistake again. I just hope that the community will forgive me. I really hope that I didn't harm the University of Connecticut community, and the University of Connecticut, and all of Connecticut, by being one person out of millions of people in the state and yelling on one night a racial slur into the air. I had the potential to really do damage to the great state of Connecticut. I know people get murdered in Connecticut. I know they do. I know there's rapes happening probably literally right now. But I am so sorry for my word that I said to nobody. I'll never talk to nobody again. Like, Nova Zero says, wait, so the court was like, y'all are arguing over didn't do nothings. Nikki, sounds like the threat of appeals makes people more likely to come back to the table. I like how Hogue supports reform, but thanks for coverage, Nikki. Okay. I haven't watched Hogue's video. All right. Next, T.R. Paulding, Corral's lawyer, said Corral is a smart young man whose conduct that night was very out of character. This is not like him at all. It is not like him to run around shouting racial slurs. It's just so unlike him. He has done well at UConn, is scheduled to graduate this spring from the university's nursing program, Paulding said. He will be nursing the very minorities that he was denigrating that night. Is very out of character. The two were captured on a cell phone video just after midnight on October 12th, yelling a racial slur for African Americans. The video was shared widely across social media and led to demonstrations on campus. That didn't lead to demonstrations on campus. Sad people did. Groups including the UConn NAACP said the university and President Thomas Katsoulias had not acted quickly enough to denounce the incident and address other racial issues on campus. According to an arrest warrant affidavit, Mukaj Corral and a third student were walking home from a pizza restaurant on the night of the incident when they began playing a game where they loudly yelled inappropriate words. Penis. 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 Penis! Okay, sorry. After repeatedly shouting penis, Mukaj and Corral, who are white, yelled the racial slur. The third student did not participate and was not charged. Oh my God, go away. Student who lives in the apartment was filming the students at the time. He told the police he heard several males outside his building yelling penis and hoped to capture them saying or doing something funny. Instead, he recorded them yelling the racial slur. Student alerted police. Get out. Get out of the country. Get out. You called the police? Get out. The student alerted police who used surveillance video and ID scanner footage from a bar that Mukaj and Corral were at that night to track them down. You are watched everywhere you go. Everywhere. You can't even drop a hard R in the parking lot anymore. They will track you down through. Listen to the CIA tactics being used to track down the word crime. Did you guys watch that show, Person of Interest? The cops invoked the security camera surveillance tracking system to find 2 idiots yelling the N-word. Can't find murderers. Find these dangerous. Corral apologized to police for his actions, saying he and Mukaj were acting dumb, idiotic, and childish. They didn't anybody had heard them. Mukaj told police he didn't remember what he had said because he was drunk, but that saying that word would be the last thing he or his friends would do. Oh, good defense. Civil liberties groups have raised constitutional questions about the student's arrest. You think? Although the conduct reported in this incident is reprehensible, it is not criminal. It's a word to nobody. David Cole, National Legal Director for the ACLU, said in October, noted they did not appear to target a specific individual, nor did their words convey a direct threat. Oh, God. Wow, look at that stunning and brave lawyer. Oh, here's the other one. We're not going to go through all this. Long story short, they are now also suing. Although the guy who did the accelerated rehabilitation, he may not have standing to sue for a wrongful arrest, or he may just lose. He may just flat out lose because, wait, you accepted your guilt. How are you wrongfully arrested? They say the school is seeking to remove them from university housing as punishment for violating the student code of conduct, specifically a section on disruptive behavior. Okay, so they're suing the university, not the cops. Terrible. Sue the cops too. Disruptive behavior policy is implemented and is written as a de facto prior restraint affording university officials essentially freewheeling and standardless discretion over speech as to content and viewpoint, as officials deem what speech falls within the policy and is impermissible. Lawsuit reads, disruptive behavior policy is unconstitutionally overbroad, unlawfully restricting speech. Good. That's good. Yeah, good stuff. University won't comment on it. The lawsuit focuses not on their arrest, but the internal discipline process. University officials held a series of hearings with them throughout the fall. After interviewing the students, a conduct officer concluded the two had violated the code of conduct and recommended the university terminate the students' housing agreement with the school. Student code defines disruptive behaviors, blah, 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 blah. Here we go. This is the important part. The lawsuit argues Mukaj and Corral are being punished for their First Amendment protected speech and nothing more. It cites a 1990 case where UConn agreed in a court order. Look at this. Not to enforce, quote, any policy that interferes with the exercise of First Amendment rights of students when the exercise of such rights is unaccompanied by violence or the imminent threat of violence. So UConn is violating its own court agreement. Now, I don't know how long that agreement was for, but presumably forever. That order stemmed from a lawsuit brought by a junior at the university who was banned from the residence and dining halls after she hung a poster on her dorm room door that said homos would be shot on sight. Whoa! Whoa! At no point in any... So what... Again, what she said is probably worse? Like, probably worse than what they said? At no point in any of the proceedings was either student accused of acting with violence or the imminent threat of violence. The school has only ever accused the students of acting orally and verbally. And when they acted orally, the school liked it. Corral, who admitted to the police that he and Mukaj had shouted the slur, according to the arrest warrant affidavits, said it was not... Don't admit it. You shouldn't have talked to him. Did you say the word? Well, I'm not talking to you. I'm not answering your questions, you communist. You fascist! Don't ever say that to cops, but why admit it? I don't remember what I said. I was drunk. That's the other guy. Smart. I wouldn't say that. We were saying, I don't even know. We were saying something else. Just yell it. The student who recorded the video shouting the slur said he couldn't hear what the males were saying as he filmed it, but when he replayed the video and turned up the volume, it became clear they were using a racial slur. Oh boy. Fire is applauding their decision to sue. Good job, Fire. Okay, that's it. I just wanted to update you guys. So Corral is here. This is the guy who is seeking the accelerated rehabilitation. This guy, Mukaj, Mukaj, I don't know how to pronounce it. They're white. So I don't know how his case is going. It's still pending. But there's that. What a great situation that is. We were saying nickel. Okay, what's next? What's next on the agenda? We've got Chris Hook. I don't want that. That was a wrong button. This one. And this one. Okay. So here is Chris Hook. We'll go to this one first. This is pretty quick as well. Just a couple pages. Avenetti's in jail. Yes, Avenetti is in jail. He requires a little more talk. I'll probably talk to the other lawyer tomorrow about Avenetti. So here we go. So this is Chris Hook's response to Allstate's request for sanctions in the amount of $41,000, right? Let me go ahead and thank Big Red 64 and S Cyber Taz for joining the channel. Appreciate it very much. In the course of settlement negotiations, Christopher Hook engaged in conduct that he acknowledges was uncivil. That conduct arose from both a personal tragedy that Mr. Hook was addressing and how the negotiations had proceeded to that point. Mr. Hook has repeatedly apologized for that conduct, which was isolated to these private communications. Notwithstanding Mr. Hook's conduct, Allstate's response to the situation was also unnecessary. Despite Mr. Hook's contrition, Allstate elected to file an application that was largely moot, save for a request for sanctions based on its filing. In other words, although Mr. Hook's comments and private emails may have led to the termination of his involvement in this litigation, Allstate's response to it was excessive and unnecessary. For that reason, Mr. Hook requests that the court award Allstate no more than the fees and costs it originally paid for as part of its ex parte application, $6,370. That's what Allstate asked for its ex parte thing. Then they tacked on a whole bunch of other stuff once the judge said, "Oh, you're gonna pay. You're gonna write a check, boy. You're gonna pay, boy. You're gonna write a check, boy." On November 26, 2019, Allstate filed an ex parte application for an order dismissing the action, disqualifying Hook from counsel, restraining Hook from communicating with or approaching Allstate or its attorneys, stopping depositions from proceeding, and ordering Mr. Hook to pay sanctions of $6,370. The costs it associated with not only preparing the ex parte papers, but reviewing the email correspondence from Mr. Hook. Allstate admits that it did not meet and confer with Mr. Hook regarding its application. If Allstate had done so, the application would not have been necessary. Now, I don't know if they have a rule that requires a meet and confer, but most places do. Like, they don't want extra motion practice. So you meet and confer so you don't double up and waste the court's time. All right. We need a little foo-you for this. Gosh, this is so disgusting. Ugh. On December 16th, the court conducted an order to show cause hearing During the proceedings, the court denied dismissal of the action, determined the disqualification of Mr. Hook and staying depositions were moot issues. Court acknowledged that Mr. Hook had apologized to defense counsel, and Mr. Hook apologized to the court and agreed that he would pay the costs and fees in preparing and appearing for the ex parte application, which all stated represented totaled $63.70. This is clever. He agreed that he would pay. Now he's agreeing that he would pay what they asked for. I don't know in court that he was thinking of this specific number, but, you know, that's what he agreed. Now, I think that's a stretch, personally, but okay. Later, Allstate submitted a memorandum claiming fees and costs in excess of $40,000. Not only does a substantial portion of the fees and costs represent conduct that occurred after the ex parte application, but several portions offer no description of how legal services even relate to Mr. Hook's conduct. Does that sound familiar? Does that sound familiar? Court would be justified in not imposing sanctions. So this is his Overton window argument, right? Look, court, you don't even have to impose sanctions, but if you're gonna, I guess the $63.70 is the amount. But you don't even have to. In assessing whether to impose monetary sanctions, the court should consider that Mr. Hook had been dealing with personal issues. Ding! Those impacted his judgment on how to proceed in email correspondence involving settlement offers. I don't know if the court should consider that or not, and I bet they won't. But it's a good try. Further, this was an isolated issue. It was isolated, but and I love Chris Hook. Don't get me wrong. I think we need settlement negotiations that, while maybe don't go quite as far as Hook, I think we should have the freedom to be more aggressive and less pretending to be cordial. The other party is often assholes. Sometimes you have to treat them like the assholes that they are. Now, the other party can also be good, right? For example, here is a rude move by another party. I can give you an example from today. So today I had a first appearance hearing for a client who's charged with multiple felonies, and the judge we were setting release conditions. First appearance is very basic. How much is bail? What are the other release conditions if the person doesn't want to pay bail, or if they're going to pay a reduced bail? All of that stuff. All right. One of the conditions that the prosecutor asked, they asked the court order my client to tell their employer about the charges. That is an absolute jerk off of a move, right? That is really, really, really petty, because you're basically telling the person that they have to go to their boss and say, yeah, I've been charged with a bunch of felonies, knowing that they'll get fired. They're innocent until proven guilty, mind you, in this country. I thought this is America. We're innocent until proven guilty. So I'm charged with felonies. To the principle of innocent until proven guilty means you're charged, you're accused, you are not guilty. You're not even at a point of being guilty or not guilty. It effectively hasn't been, the question haven't even been asked yet. Okay? But what an employer hears is, I need to be fired. That's how an employer hears, I've been charged with felonies, right? Because if you are guilty, the training that they did goes out the window. You could be in the news. Any number of factors go into that. So that was a jerk move by the prosecutor. Now, being in court and observing the rules of decorum, I merely objected on First Amendment grounds, and we won that objection because it was ridiculous. It's a stupid request. It should not have been asked. It's offensive that a lawyer would ask a court to order someone to speak to another party. You must speak to an unrelated party and tell them specifically this is the antithesis of the freedom of speech, right? The state will force you at gunpoint to say these words to someone else. We don't do that. We don't do that here. And make no mistake, this is a release condition. If you do not say the words to the employer, you go to jail. And if you don't go to jail, we put the bullet where we want to. That is how this works. So anyway, and we should be able to call the other party an asshole when they do that. Like, what are you thinking? That's a flagrant violation of the Constitution you're sworn to uphold. How dare you? Right? But anyway. But in all of that, I love Chris Hook. I think what he did is funny. I think it's like a lawyer Hulk out in some sort of way. But at the same time, you can't pretend it was an isolated incident. It was several communications over a period of time. It wasn't just one email or one phone call type thing. And as soon as somebody complained to Mr. Hook about his communications, he both apologized and stopped using inappropriate language. When he appeared in court, Mr. Hook likewise apologized. The court should limit the amount of sanctions imposed to the amount Allstate originally requested. There are significant problems with the memorandum of fees and costs that Allstate submitted. First, Allstate failed to mitigate any issues raised by Mr. Hook's private settlement communications. Oh, excuse me. Among other things, it did not meet and confer to see what issues actually required court intervention, which could have severely limited the time required to address the matter, likely obviating the need for the court's involvement. Second, the submitted billing information shows a pattern of unreasonable practices, including impermissible block billing, excessively researching issues beyond what would be reasonably required, and duplicative work. Does this sound familiar to you guys? It sounds kind of like we've heard these arguments before in a different case. A summary and example of problems with the billing set forth in Exhibit 1 are as follows. 8.6 hours to read settlement demands. 8.6 hours. Guys, the emails are like a line long each. 7.9 hours to research a 7-page ex parte application. 16.8 hours to draft the same ex parte application and supporting documents. So there you go. 2 hours a page. In excess of 2 hours a page to draft that. Whew. 10 hours for 2 lawyers to review opposition papers. 10 hours. 20.1 hours researching and drafting a reply on the same issues. 1.7 hours researching what plaintiff's new counsel's rights, something completely unrelated to the expense of an ex parte application. 3.7 hours for fees with no description of work done. 1.8 hours communicating with and reviewing media items, something completely unnecessary for the application. 9 hours for different lawyers to travel to a 17-minute hearing. 4.1 hours to prepare for a 17-minute hearing. 3 hours of tasks that occurred after the last hearing. So there you go. That's in short, Allstate acted to incur fees that were excessive in dealing with the situation that could have easily been contained. For that reason, it is appropriate for the court to limit Allstate to recovering only those fees and costs that are reasonable. Do I think this is going to work? No. No, I think this judge wants to make a statement. But they have to raise these issues. They could appeal the sanctions order. Although Mr. Hook believes that a reasonable sum is an amount less than the $63.70 Allstate prayed for, he also acknowledges that he agreed to pay that sum at the December 16th hearing as what he believed and understood was a compromise. For these reasons, the court should impose monetary sanctions against Mr. Hook. It should impose no more, or should they impose monetary sanctions, no more than $63.70. Conclusion, even after Mr. Hook made statements containing foul language, these proceedings were avoidable and unnecessary, and the billings that Allstate has submitted shows total amount requested is unreasonable. Mr. Hook has apologized with sincerity If the court elects to award sanctions based on fees spent, that amount should be limited to what Allstate initially requested as part of its application, $63.70. So that is from Chris Hook's lawyer. Let's briefly take a look at his 2-page declaration. And we'll see why Chris Hook acted this way. I, Christopher G. Hook, hereby declare I'm an attorney at law, duly licensed to practice before the courts in the state of California and U.S. District Court for the Central District of California. I have personal knowledge of the following facts, and if called upon as a witness, could competently testify hereto, except as to those matters which are explicitly set forth as based on my information and belief, and as to such matters, I am informed and believe they are true and correct. I have been admitted to practice law since 2008, have no previous record for discipline. Here we go. This is the sad music. I've been dealing with the recent loss of a close family member. As a result of that, I still have some emotions that have been raw, and I've sought assistance in dealing with them. Hopefully he called Lawyers Concerned for Lawyers or whatever. They'll help him out. In this litigation, my interactions with Allstate's counsel were unlike those that I had previously had with the same law firm and other matters. I became frustrated and reacted in a way that I have since apologized for. Allstate's counsel neither met and conferred with me regarding the language I used or attempted to resolve any disputes that arose out of my language before seeking court intervention. Had Allstate done so, I would have immediately addressed the issue as evidenced by my conduct, which has not involved any foul language, following my receipt of notice of the ex parte application. My first notice that Allstate viewed my language as a problem. Notwithstanding the emails I sent as part of private settlement negotiations, my conduct in deposing witnesses in this matter, in pleadings in law and motion, and other communications has been free of any foul language or other uncivil conduct. I've previously apologized to the court and to Allstate's counsel for my conduct and do so again. I declare under penalty of perjury under the laws of the U.S. the foregoing is true and correct, and that this declaration is executed in Los Angeles on this 14th day of January 2020. So there you go. That is his declaration. He was dealing with the loss of a loved one. He wasn't in a proper state of mind, and the fee should be reduced. He's going to eat those 41 grand in fees from this judge. That's my thought. The judge is just going to award him that 41 grand in fees. So he'll punish him with having to pay those lawyers to fight an appeal. That's what's going to happen. So, that's where we're at for the day. We should probably wrap up the show pretty soon here. Got some chats to read. But I mean, that's the majority of stuff I was going to talk about. Tomorrow we'll talk with another lawyer. I'll introduce you guys to him, and we will have a discussion about hopefully all sorts of stuff. Maybe we'll talk Avenatti. Maybe we'll talk about Virginia banning firearms. Maybe we'll talk about the impeachment. Who knows? Who knows? But if you are someone who leaves during the chats, thank you for hanging out today. I will be doing Twitch after this, so come join me over on Twitch, and we'll have a good time over there as well. I'm going to read the Justice chats and then the Super chats, and then we will be done with the show for the evening. I appreciate you all coming very much so, and welcome to all the new members. We have a cooking show coming up. Godzilla, yeah, probably Dark Souls again tonight. So, here we go. Let's check out the first one. It's from Anonymous. It says, an I Stand With Vic person tweeted a bad take about a Revenge RoastCon panel against Amanda Winn Lee, then deleted, apologized, and disavowed 20 minutes later in a new tweet in the old thread. 30 minutes after, Spectre06 posted a screenshot of the deleted tweet as a gotcha on them. Yes, I know. I responded to it. Then another anonymous person says they replied to Spectre06's tweet with another apology and explanation, which was ignored completely. Chill out or F off, you weirdo. We get enough of that BS from the SJWs. So I don't know who the two anonymous people were. They were before the show, I believe. Yeah, well before the show. Keylancer13 says, Nick, ever heard the song Ghoul Wrangler by Clutch? It's about undead flesh-eating lawyers, which I'm pretty sure makes it the song of your people. All undead flesh-eating lawyers is redundant. Bad Dragonite says, what anime arc are you looking forward to the most? Civil War Season 2 or World War Season 3? It's the Roaring 20s, man. So probably Depression Season 2. Khan says, hey, Nick, recently found your videos. I was Vic's handler at 2 large conventions. I've never seen him act in the manner described by people recently. The only issue I had with him is that he talked far too much, making him late for things. Yeah, he does that. He does do that from time to time. Crusader Saracen says, Legal is technically right, but also so full of shit. And then he also says, do you and Drexel ever shake hands like they do in Predator, only much more skinny instead of muscly? No. So yeah, as to whoever Khan is, man, if you ever wanted to anonymously share some stories, my emails are open. All right. Talbot Link says, media channels, impeachment, 3rd time this has happened. Me, Andrew Johnson, 1868, dumbasses. Well, Nixon was never impeached. He resigned prior to the impeachment. That's probably where they're getting it. Stars Girl Forever says, hi, Nick. Thank you for the educational fun times. Hey, you're welcome. Hopefully they are fun. Green Bullet Prod says, yes, I meant your name earlier. Chat said a silent voice, and that's really good too. My friend man cried during both. I laughed at him. Does that make me heartless? No. No, there is no man cry. What is a man cry? Is that where you go outside and just shoot your guns into the air? Is that man crying? Because that's what I do. TLJ Screwjob says, oh no, low battery mode, Vic Boomer Mignogna. Oh, I was going to bring that up. Justice Roberts dropped the OK Boomer meme at a Supreme Court hearing, asking if it would be age discrimination if someone mentioned to an elderly applicant OK Boomer. And the lawyer had some crappy answers for him. Boring. That's about it. When I saw the headline, I was like, please tell me a lawyer got done with his oral argument at the Supreme Court and Justice Roberts went, okay, Boomer. That's a funnier story. That's a much funnier story. Sean Fallon says, just got a new job and thought I would support one of my favorite YouTubers supporting one of my favorite VAs. Got to wake up in a few hours to start work. Wish me luck, chat. Hey, good luck, buddy. Go get him. CJ says, cover the trial by combat request in an Iowa District Court in Shelby County divorce. I've seen it. I mean, there's not much to cover. We'll probably laugh about that tomorrow too, or I'll save it for a big brain panel. But basically, a man in a divorce proceeding has requested leave from the judge to conduct trial by combat via sword with his wife and her attorney. So there you go. Good job. Sefi Hakubi says, much thanks, Nick. I'm very determined. Scored my first contract this past weekend, and I'm 100% sure I'm all man. My avatar is my bald self with headphones pointing at one of my logo. Best wishes. Oh, okay. I can see that. Yeah, that makes sense. Rural says, I joined for the drunken rants. Hey, thanks. Welcome. Some nobody says, you're doxing him on stream. Scree! I'm sure. Another felony by Rekieta law, right? Bad Vibe says, Jukin missed a business partnership with MxR. Jukin should have used MxR as a promoter, but, greed. Well, they should have done it smarter than they did, but they probably ended up with that result, in all honesty. Fluffy Tet says, your membership should be called Racketeers, so Super Chat billing shows up as racketeering charges. Stabby McStabswood says, I don't support Jukin's actions at all, but this BS doesn't pass the sniff test. These kids definitely use a situation for capital gain. X to doubt. What, a 1 million view video? What are you talking about? Guns Down in Hail says, quartering confirm e-beggar from his own mouth. Wow. Gawker's Death Rattle says, Legal Eagle kind of looks like someone trying to fashion a plasticine version of Don Draper and not quite getting it right. Ouch. Lee Ditzworth says, did you see creepy porn lawyer got arrested? A danger to the community. Avenetti's a danger to everybody. Looks like anyway. Looks like a danger to everybody. But yeah, I did see it. Oh man, imagine your disciplinary hearing to determine if you even get your bar license, and then when you get done, the IRS is like, hey, by the way, have a seat. Talbot Link says the big brains talk about filing impeachment named Nixon, Clinton, and Trump. Oh my God, that is embarrassing. A Yellow Jacket SA says Legal Eagle, sound and fury signifying nothing. Silverwolf 0080 says, what do we have to do to get you to stream in a suit for like half an hour? I don't know. That's a good question. Maybe we'll do a charity stream sometime where I wear a suit. Architect of Fate says, the Young Turks, sorry I wasn't paying attention, Law Daddy. When did we switch topics to the Armenian genocide? When are we not? Wait, did that even happen? Let's ask Cenk. Some nobody says, no, YouTube commentary has just always been shh. Poop. Stalin Falcon says, yes, fees, community service requires payment. Diversity education will also guaranteed have an associated fee. This is BS. It is. It is. But is it worth fighting it for him? That's the question. S. Cybertaz says Helen Keller could have drafted that reply faster. Welcome to the joining the channel, S. Cybertaz, if I didn't welcome you earlier. Louise Orton says, hey Nick, did you see my email? Yes, I did. I think. But I can never remember on stream what a specific person's email was. But I'll make sure and respond and confirm. Asia Fraser says, ever played Dead by Daylight? Nope. And then we just read the one from Talbot Links. Crusader Saracen says, Nick, what happened to true male friendship? Why does popular culture seem so intent on just killing it? I don't know. Actually, that's a really good question. It's something a different friend of mine and I have talked a lot about. Friendship has changed dramatically, and well, male friendship is dangerous. I think that's the reality here. Male friendship is a dangerous thing. If you have allies, you can't be beaten down as easily. I think it's not much more complicated than that. So. And then finally, Animat has blocked me on Twitter. Rip me. Rest in pepperoni. I am with what's his face's pupper that Ian Miles Chong flashbanged vicariously. It's gone. I can't. I simply asked if he would like to talk, and now I've been blocked. I asked him 2 times ever. So there you go. I tried doing it for you guys. I don't want to talk to Animat that much. But I know you guys want me to talk to Animat that much. I'd like to answer his questions and clear up some of his confusion. But he just won't do it. Which makes me a sad boy. So. All right, guys. Well, that's what we got for today. Thanks for hanging out tonight. I really appreciate it. You guys are always great. Got the lovely taste of Fuyu to close out the evening. Let me get me get the outro playing. Phoenix Arum says, late and gayer than Liberace. Happy belated birthday, Nick. We share a birthday. Hey, happy birthday back to you. Just got my dream job. I'll check in when I have time. Godspeed. Hey, congrats, man. Hope it goes well for you. Hope it's a wet dream job. But, all right, guys. That's all I have for you. Come hang out on Twitch. I'll be in a tank top. We'll be playing Dark Souls. I'm better at it than I was when I started. I don't know if that's saying much. Maybe we'll finish it today. I think I have a long way to go. I have no idea. Alright, guys. Wait? Wait? Wait for what? I'm waiting. What? You've made us proud with your growth, Nick. Bet you say that to all the boys. I'm just waiting for whatever Phoenix has to say. Oh, you read it. It's all good. Okay, good. I forget you're behind. All right, I'll talk to you guys later. See you over on Twitch if you join me there. Peace. If not, peace. See you tomorrow. Peace.
Perspective and spice to the mix. But the reason we're here,
eventually, Rekieta or one of his followers, they're gonna commit a crime. They're gonna have nowhere else to go. They commit a crime. It's gonna be a crime. They're gonna crime someone to crime. They're gonna crime them to death. Rekieta and his followers, they're gonna crime someone to death.
Get unemployed, so pour out a glass for the tea. Post on Twitter as we hear lost painting tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who's